MorningClickOrlando.com. I'm morning anchor Kirsten O'Connor, sitting next to Jason Johnson of the Lowndes Law Firm. He is one of our legal specialists here at News 6. Thank you for being with us.
My pleasure.
And so today we're talking mainly about what happened yesterday in the courtroom. We are talking about the Noor Salman trial. It's Tuesday, and yesterday we found out that the judge did not accept that mistrial.
Right. So late Sunday evening, the defense filed a motion with the court to either dismiss the case or for a mistrial. Everybody woke up to that information on Monday morning, and as was the case with the motion before the trial started, which was really a motion in limine and then a motion to acquit last week, as well as the judge's comments in court last week about the government continuing to use this argument that Noor Salman case pulse when the forensic evidence didn't support it. All those things tend to get people riled up and think something big is going to happen in the case. This may be the bombshell that throws this case wide open or ends up in a dismissal or a mistrial, and then it ends up being a bit of a thud for people. It's not necessarily surprising to lawyers, but to lay people it tends to be a bit shocking that he simply denied this motion. And, you know, being in court and listening to his rationale yesterday, it's pretty clear that he had a good basis for doing so. There are a couple of cases out of the Supreme Court that were the basis for the filing of this motion. One is called Brady and one is called Giglio. And the Brady decision says that the government has to turn over any information to a criminal defendant that would tend to exculpate or show the innocence of that defendant. The Giglio case extends to information that would provide basis for impeachment, but as the court noted, the Giglio case only applies when you're talking about the government's own witness. And the fact that the government had Sadiq Mateen on its witness list was immaterial because they never called him. And because they never called him, then the information that they didn't turn over until Saturday afternoon regarding that person was not a violation of that case law because he was never called as their witness. Had they called him as a witness and not disclosed that, the government may have had a problem, but they didn't do so. So the court denied the motion on that grounds. And then the defense also argued that, hey, if we'd known that Sadiq Mateen was a confidential FBI informant, we may have come up with alternative theories of the case. And one of the big ones that they noted in their motion was that they went after Noor Salman basically to divert attention away from the FBI's own ineptitude in failing to prevent this attack from the son of their own confidential informant. They were embarrassed by that. They wanted to divert attention away from that, so they framed Ms. Salman and prosecuted her for this. The judge addressed that and said, look, to accept that as true, we basically have to accept that the government's entire case is one big frame-up job. And that argument is so attenuated that I'm ruling that the failure to disclose that is immaterial. You wouldn't have come up with that. It wouldn't have been a valid defense. And so he just denied the motion. He did disclose at the end of the last witness of the day that he was going to be coming back, and we all expected him to say, you know, to issue a ruling or to hear oral argument on this. He's heard oral argument on a number of motions thus far, but instead he said, I've already ruled this morning in a sidebar, and so I'll come back on the record to let everybody know. At that point, I kind of knew that he was denying it. If he had ruled this morning in a sidebar that he was granting the motion, we would not have had a full day's testimony. So the fact that he had a full day's testimony after ruling in a sidebar indicated that he was denying the motion, and so we got to simply sit there and listen to his rationale for doing so.
So is there any reason why the government did come forward and talk about Sadiq Mateen as an FBI?
Well, the court...
Why would they do that? I mean, it was a Saturday. Why did we get that information when we did?
The interesting part of the communication, and the entirety of the communication is included in the defense's motion. She says, I've now been authorized to disclose this information to you. So I'm not sure why it wasn't disclosed earlier, probably because the government knew that they weren't calling Mr. Mateen as a witness and didn't want to disclose at that point that he was the target of an FBI investigation. So they also say, you know, during the course of our discussions with him after Omar Mateen committed this attack, we searched his home based on a voluntary search on his part, and we found some documents that evidenced payments overseas, and that triggered an FBI investigation of Sadiq Mateen. And so they probably didn't disclose this earlier because they didn't want to let him know he was the target of an investigation. But since he was on the defense's witness list and that they thought the defense may call him, they wanted to let them know that if you call him, there's this information you should know, but we will not address it on our cross-examination of him. But the court said that is not a violation of Brady or Giglio.
Do you think that that the defense will call Sadiq Mateen up?
No, I think, this was an interesting development yesterday, and I think they may have been thinking about calling him, but had they called him, it would have made for an interesting dynamic in trying to, this happens in criminal trials a lot where one defendant says, I'm pointing the finger at the other guy. In this case, she would have to be pointing the finger at the grandfather of her son, her own father-in-law, which would have been interesting. But also it would have undercut their argument a bit that we can't present a valid defense based on this theory when they did so by bringing him to the stand and pointing the finger at him. So I don't think they did it because it would have undercut their arguments a little bit. I guess they also felt that the information they would have gotten out of him wouldn't have done anything to raise reasonable doubt in the juror's mind.
What it does do, though, is raise a lot of questions for
Sure.
all of us. We all want to know now what they were investigating, what they found. And do you think there's any possibility of some sort of criminal investigation into him?
It sounds like the FBI is already investigating him for these payments overseas, and the court said, the court acknowledged when addressing that, hey, sending money overseas is not necessarily illegal. It can be in certain situations if you're funding terrorist activities, but the fact that there's an investigation doesn't necessarily mean he did anything wrong. He just wanted to make that clear. But he could be the target of an investigation. He could be the target of another federal criminal trial if it shows that he was either aiding and abetting his son by sending money to Turkey when Omar Mateen was searching flights to Turkey. It could have shown that he was trying to set his son up, and therefore he knew about the attack, and therefore he was aiding and abetting his son in the attack. If there's evidence that he was involved in the planning of it, he could be charged as a co-conspirator and tried. So, Mr. Sadiq Mateen may be facing some criminal charges in the future, or it may turn out to be nothing. We don't know that yet.
But regardless, I guess the point coming into Tuesday here is that this doesn't affect Noor Salman and her trial.
No, it doesn't affect Noor Salman. The judge made that point, and I sort of made the same point yesterday afternoon, which is even if they wanted to point the finger at Sadiq Mateen and say he was the one that was aiding and abetting, the aiding and abetting charges aren't mutually exclusive. You don't have to have only one person aiding and abetting. He certainly could have been aiding and abetting over here, but that doesn't mean that Noor Salman wasn't also aiding and abetting her husband in this attack. And I think the government has a lot of evidence to support their claims that she was doing that. I don't think they're going to call him. I think the court indicated yesterday afternoon that their final witness is going to be called this morning, and that's going to be their expert witness on false testimonies. And so I expect we're going to have probably a half day of testimony from that witness. And then for all intents and purposes, there may be a short rebuttal case by the government, but Ms. Sweeney indicated that that may only be 20 minutes. So I think we're going to be at the end of witness testimony and the admission of evidence today. We'll get into the court addressing the final jury instructions tonight, and tomorrow we're likely to have closing arguments, jury instructions, and the jury may get this case as soon as tomorrow night.
How long do you think it'll take the jury?
Reading those tea leaves is impossible. All it takes is one juror to say, hey, I'm not sure how many wives have husbands who they don't know exactly what they're doing. You haven't convinced me beyond a reasonable doubt, so we need to stay here and try to convince that person. Or you could walk in and they all say, let's just stop and raise our hands. Who thinks she did it? And that could be the end of it. You never know how a jury is going to act.
Is that what part of the instructions are about?
Well, the instructions are definitely detailed instructions on how you are to view the evidence, what the burden of proof is, the fact that you must return a verdict of acquittal if you don't find that the government proved its case beyond a reasonable doubt, what the elements of the crime are and what the government had to prove each of the elements of the crime. So they're lengthy jury instructions, but you never know how a jury is going to act once they get into the privacy of the deliberation room.
Closing arguments. We talked a little bit about the personalities of these attorneys that are in the courtroom before we started this Quick Orlando live question. But what do you expect from them? What do you think that these closing arguments will?
Well, they're all professionals. They're all very good lawyers. The government is going to present its case again to the jury by summarizing the evidence that they've shown. Their job right then is to serve up the case on a silver platter to the jury and say, here's all the evidence, here are the charges against her, here's the evidence that we've gotten admitted into the court that prove that she did it beyond a reasonable doubt. This is all yours, take it back to the jury room and come back and find her guilty. The defense's job is not to say she's innocent, it's just to say there's reasonable doubt. And they can try to poke holes in any of the government's evidence to try to do that. And obviously the big thing that they're going to try to do is say this statement that they claim is a confession is not a confession, it's not her words, it's not her handwriting, she didn't write it down. And even if it were, the fact that it states that they cased Pulse when we know that that's not true, it's demonstrably not true, means that you can't trust any of it. And if you can't trust any of it, that's reasonable doubt and you can't convict her. So I think this case in the deliberation room is going to hinge on that written statement. The government's going to say, you know, Agent Enriquez wrote it down, but if you look at it, and they will have the copy of the written statement, every single paragraph has her initials at the beginning and end of each paragraph. And at the end of each statement, she handwrites some notes. So, you know, the fact that it may not have been in her handwriting is immaterial. These are her words. You heard Agent Enriquez say, I wrote down exactly what she said. I think at one point he said, she could have told me she'd gone to the moon and I would have written it down. Because my job was to write down whatever she was saying. So I think the case is going to hinge on their belief of that statement and whether they think it's true.
One of the things a lot of people have taken away from this, though, is not, she's not on trial for knowing. She's on trial for aiding.
Right. She's not on trial for either conspiracy or for simply knowing. Aiding and abetting, just showing that she knew about the crime is not enough to convict her of aiding and abetting. They have to show that she took some act in furtherance of the crime to convict her of aiding and abetting. And the government points to her written statement. They also point to the evidence that they have that they went shopping. They spent a significant amount of money, more than an entire year's salary of his, in the weeks leading up to the attack, showing that not only did she know, but that she was taking steps to financially prepare herself after the attack, that she helped case. She may not have cased Pulse, but they're arguing that she cased Disney Springs, she cased City Place down in West Palm Beach, and the fact that she may not have cased Pulse is really immaterial to whether she aided and abetted in his efforts to commit a terrorist act in the United States. And so I think there's sufficient evidence if the jury wants to find her guilty. It's just a question, I think, of whether they believe that written statement.
Right. And that's what we will find out potentially tomorrow.
Well, I think there's a good chance that we could have a verdict by the end of the week.
Yeah.
But we could also be looking at next week if they don't reach a decision quickly.
Yeah. All right. Well, Jason Johnson of the Lons Law Firm with us as our new 6th legal expert. Thank you so much for joining us on ClickOrlando.com. We will have another one of these discussions followed by a little bit of discussion from inside the courtroom from our own Nadine Yanis coming up at 12:30 right here on ClickOrlando.com.